All right, so we're going to start at page 9. Let's put on our roller skates. So the first case is item number 1, and it's a case involving Westlands Water District, which just happens to be the largest water district in the nation. It's about the size of Rhode Island. The area it covers, about 1,200 square miles of property. And it's always at the foreground of some controversy, unfortunately. But I thought this was an interesting case because it appears very basic. And the reason they lost this proceeding, and I'll talk about it in a minute, this validation proceeding, is because of very basic contract principles that law students learn their first year of law school in contract. You have to have offer, you have to have acceptance, and you have to have consideration. And all the terms surrounding all three of those have to be specific enough that a court could really determine whether or not you're in breach of anything, and whether or not your contract is valid, and whether or not you're in breach. And here, the contract was deemed not valid because as to the consideration, the amount of monies to be paid, this contract was simply not clear. So they lost over a very simple legal issue. But what's not so simple is the background, and that's what I want to talk about because that's pretty interesting to me. So the milieu of this is a controversial, polarizing contract entered into between the Bureau of Reclamation and Westland Water District during the prior administration, the Trump administration. And what happened, and I'm going to give you a little bit of a background. So in 1963, Westland's Water District had contracted with Bureau of Reclamation for Central Valley Project water. And at that time, they had entered into a 40-year agreement. Fast forward to 1992, Congress passed what they called the Central Valley Improvement Act. And that act is extremely significant because it elevated fish and wildlife, both protection and restoration, to a stated purpose of the Central Valley Project Administration. So Congress was on top of this. They knew there was going to be an issue, that that the Central Valley Project shouldn't just be about providing water. We've got to take care of species, we've got to take care of habitat, and it is going to be a stated purpose of the administration of the Central Valley Project. And of course, that's wonderful for the environment and very difficult for water districts that need water as quickly as possible at decent rates. So the act prohibited new water contracts, but it allowed for 25-year extensions, a maximum of 25-year extensions on existing contracts. So Westlands was in a good position. It had its contract. It could request a 25-year extension. But in reality, they weren't so comfortable with that because it requires compliance with NEPA. It requires the preparation of an environmental impact statement and going through that process under NEPA. And because the NEPA process can take a while, the Bureau of Reclamation, the act allows the Bureau to issue one interim renewal contract for a term of up to 3 years, followed by a seemingly endless quantity of 2-year interim contracts until the environmental review under the act is complete. So you kind of have to live by these 2-year contracts until all that environmental analysis was done. But Westland Water District got a little creative, and in 2020, they noticed that there's another act that had been adopted in 2016 called the Water Infrastructure Improvement Act for the nation, the Water Infrastructure Improvement for the Nation Act, or WIN, and that was adopted in 2016, and they could convert their existing contract with the Bureau of Reclamation to a prepayment contract. So if they were willing to prepay under this other totally remote legislation, they could do that. Like, wow, we've got the money, let's try this. So, working with the administration in 2020, they entered into this contract, and a couple of other benefits. One, they didn't have to comply with NEPA. Two, it also, they were not subject to certain acreage limitations, so that probably expanded their ability to, it did expand the area within which they could use the water. And there were some related pricing provisions that there were also benefits under, but it was a prepayment situation. One news outlet referred to it as a sweetheart deal with the prior administration. The problem is this: they still had to seek validation of this contract. So under validation law, there are specific types of public contracts that have to be validated by a court, and this was one of them. So they went to court to seek validation, and of course, it was denied, and a coalition of Native Americans, commercial and recreational fishermen, scientists, environmental groups, and the like opposed the contract. They opposed the validation vehemently, saying there needed to be more scrutiny and what have you. And they focused primarily on the omission of the payment information. So right back to the consideration. That very simple issue is what got them here. And so the court ended up, the trial court denied the validation based on that simple contract principle. The Court of Appeal upheld the trial court's denial of the validation, and they sought Supreme Court review, which was denied. What the court did note, however, is that, yes, this is a victory by environmentalists, but the court's holding doesn't really purport to rule on the merits of the contract, but it's limited to the faulty contract drafting in this case. So perhaps another validation proceeding will come forward, and they'll modify the contract, and we'll see what happens. We'll continue to follow that. But I thought these cases that seem very simple sometimes have a very interesting background. And as we know, environmental law is just very political, as land use law is as well. Okay, next at page 10. And a few of these I'll spend a little more time on, some I'll go through more quickly. And I think we've all read in the news that the Department of Water Resources, they've certified the final EIR on the single tunnels, no longer twin tunnels. And about 9 lawsuits have been filed in January. There's a total of 33 plaintiffs that have sued. It includes all the Delta counties, City of Stockton, environmental and other non-governmental organizations have sued. We'll continue to track that. But here we have a validation proceeding situation again. So the Department of Water Resources somehow has to finance this project, which has a $16 billion price tag. So they tried to sought to issue revenue bonds based on a law that was last amended in 1959, and it's aimed at making improvements to the state water project. And they had to go to the Superior Court with a validation request, and the Superior Court denied it. And at this moment, DWR downplayed the scope of the ruling, but the Superior Court said, no, thank you. We believe that you've exceeded your delegated authority when you adopted those revenue bond resolutions. So DWR is going back to the drawing board. They will not be completely stymied by this, but they've said they're considering an appeal, and they may have to look at some other financing measures. Okay, page 11. So the topic has to do with Department of Water Resources deeming basins are inadequate. They have inadequate groundwater sustainability plans. So we've talked over the past years about the adoption of the Sustainable Groundwater Management Act. It happened in 2014. And as part of that, local groundwater sustainability agencies were formed, and those agencies in medium priority basins, medium and high priority basins had to develop groundwater sustainability plans. And thus far, things are going pretty well. There are groundwater basins covering 98% of the state's groundwater usage, and they're being actively managed by the groundwater sustainability agencies. And they have submitted, both the medium and high priority groundwater basins have submitted their groundwater sustainability plans. And DWR has provided input feedback. They have 180 days to respond, and it's going pretty well for most of the groundwater sustainability agencies, except for 6 of them. And those 6 will end up going to hearings before WDR this year. The 6 basins where they are, the DWR believes their sustainability plans are inadequate and are triggering state intervention. And those 6 basins are Chowchilla Subbasin, Delta Mendota, Cahuilla Subbasin, Tulare Lake, and Kern. No, none right up here, but those basins will have, they're on probationary status, and they will each individually go to a hearing before the Department of Water Resources to defend their groundwater sustainability plan. If Department of Water Resources so chooses, they can take over management of that sustainability agency, implement their own, draft and implement their own plan if need be. And this is actually somewhat similar under State Mining and Reclamation Act, where there was a period of time where the Mining and Geology Board was wresting control of local government's authority over SMARA matters, over reclamation plans, and all that was probably, 15 years ago or longer, and all that got sorted out, and the control went back to most of the local government agencies. But this is a little bit similar to that. All right, so the next item that I'm going to talk about is at page 12. It's item number 4. And Governor Newsom signed a bill, and it was, I think I had a note here. Yes, the Planning and Conservation League was the sponsor of this legislation of SB 389. And what 389 does is it gives the state regional water quality control board more control and authority to investigate pre-1914 rights and riparian rights. And some interesting facts here about the amount of water, and how many, here we go. Yeah, the pre-1914 water claims account for the diversion of over 2.3 million acre feet of water a year from the Sacramento-San Joaquin Delta watershed. So that's a large chunk of water that a pre-1914 right they're reporting, they're claiming to be using this much water, and the state hasn't really done too much investigating of those claims. And the same is true of the riparian right holders. So they want to get their arms around not just what the water right holders who have had to obtain appropriative rights, but as to the water right holders that have claimed pre-1914 rights, as well as the riparian rights. They want to be able to see, are these rights truly valid? Now, the original language actually wanted them to not just investigate, but to kind of prosecute, and it was negotiated. That language was pulled back a little bit. In reality, I think the State Water Board has always been able to investigate pre-1914 and riparian rights. We have clients where the State Water Board has come in because a neighbor maybe has complained about a winery's usage of water, or allowing spring water or surface waters, or whatever type of waters in their water portfolio, and the State Water Board has come in and said, do you really have this much water? Can you really use this much riparian water? And so, or your pre-1914 right claim. So I think they've been doing it all along, but the Planning Conservation League wanted to step it up, make it more formalized, but it's not quite as formalized as recommending that they prosecute, but it's encouraging and providing funding for more investigation. So if any of you are dealing with someone with a water right, be prepared. They may come looking, even if a neighbor's not complaining about something. Okay, so we're going to skip items 5 and 6, and I just want to make a comment about item 7 at page 13. And another bill Governor Newsom signed into law is Senate Bill 337, and this establishes the goals of conserving 30% of California's state lands and coastal waters by 2030. And it codifies the governor's 30 by 30 agenda, and it's a conservation approach endorsed by scientists to prevent mass extinction and ecological damage in the future. This bill was sponsored by the Defenders of Wildlife, and the land and water preservation is a further advancement of the climate goals by protecting biodiversity and ecosystems to reduce greenhouse gas emissions and by sequestering carbon. So once again, the Defenders of Wildlife has stated California is, quote, a globally significant biodiversity hotspot with the highest concentration of species that can't be found anywhere else on Earth. I don't know if that is a scientifically correct statement. It wouldn't surprise me. It's a bold statement, but they believe it, and they sponsored this bill, and it is consistent with the governor's 30 by 30 plan. Okay, and so now we're going to move on to page 14. I want to just talk a little bit about drought management at the state and local levels. And our materials talk about the 2020 executive orders. Once again, it's not a regulation or a statute or a case, but it's an executive order. In 2022, they were trying to increase the drought response. Now, the latest drought-related executive orders were signed in 2023, and that was in March, and they rolled back specific provisions that weren't necessary due to current conditions, but they wanted to maintain other measures to support some regions, some communities that still have water supply issues, and they want to support long-term water resilience. The 2023 order responded, as I said, to current conditions, but it preserved a few smart water measures. I'll just go through a few of those. They're in your materials. One, they maintain the ban on wasteful water uses that will always exist in California, such as watering ornamental grass on commercial properties. That's deemed a waste. They preserved all current emergency orders focused on groundwater supply, where the effects of the multi-year drought continue to be devastating, even though we've got abundance of snow. Groundwater regions have been, or groundwater basins have been impacted. And then he maintained all prior orders focused on specific watersheds that have not benefited as much from recent rains, including Klamath River and Colorado River basins, both which, believe it or not, remain in a drought. And then the next item is at page 16, which is kind of part of this discussion on drought measures. We just had to deal with it and examine Napa County's integrated approach to well permitting, because well permitting, groundwater well permitting over the years has become increasingly more restrictive. Counties, lead agencies are overseeing the requiring CEQA. And beyond that, Napa has a pretty interesting integrated approach to well permitting, where they integrate the following requirements all into one process. It includes CEQA, the preparation of a water availability analysis, a GSP implementation if the groundwater well is in a basin that has a GSP. They examine state and county drought emergencies, and they look at recent court decisions. And that's really what any jurisdiction should do if they have a well permitting program. You don't necessarily have to follow the exact approach that Napa has. They have a 3-tiered approach. We don't need to go into it, but I just thought for those of you at public agencies who might be considering managing groundwater well drilling and permitting a little bit differently, I thought this was an interesting example. And all those bullet points from CEQA to looking at recent court decisions all make sense before examining those before issuing a well drilling permit. Okay, and so with that, we're going to go on. We're done with the topic of water supply. We're going to go on to water quality at page 22. And I'm talking for a few more minutes, then Glenn will jump in. So the first case I'm going to talk about is Stone versus High Mountain Mining. It involves a question of a potential discharge from a point source into navigable waters and whether or not the facility that is operating results in the discharge has to have a permit for that discharge. And in this case, we go back and look at the Maui case that we talked about a few years ago as well, where the Supreme Court identified criteria for determining whether or not a permit is required for a point source that ends up in navigable waters through a series of other measures, for example, through groundwater. And so here, in this case, the mining operator operated a mine in Colorado. The materials were excavated and brought to a processing plant where river water was used to wash the materials to recover the gold. The processing plant discharged the wastewater containing all these fine-grained materials, sand, clay, and silt, into a series of collection ponds that were not lined. And they were located on site, and that was put into these collection ponds. It's then cycled, the wastewater is then cycled through various the collection ponds before it's recycled back for use in the processing plant. And as I said, all the ponds are unlined. So the plaintiffs filed a citizen enforcement action under the Clean Water Act alleging that the mining operator needed a permit, an NPDES permit for this discharge, or they needed WDR's waste discharge requirements, because they claim that the wastewater is seeping into the ground and gradually flowing into a nearby river. So it's not flowing over the top. They claim it's seeping through these unlined ponds into the river, which is a WOTUS water of the United States, and it's an unpermitted discharge from a point source. So the district court, the lower court, held in favor of the plaintiffs, said that those collection ponds are point sources, and the defendant's usage of those where the wastewater seeped into the groundwater and gradually flowed into the river was an unpermitted discharge and required a permit. The district court knew they had to look at the Maui case, where the United States Supreme Court a couple of years ago created a new test for these types of cases when pollutants might originate from a point source, but they're conveyed through to navigable waters from a non-point source, such as groundwater, as an example. So in Maui, there was a wastewater facility that released partially treated sewage through underground wells, traveling through groundwater before entering the Pacific Ocean. As to that case, the district court applied only the first three Maui factors, I'll talk about those in a minute, and concluded that the mining companies discharged the groundwater from the unlined collection ponds, which then seeped through to the navigable water, was the functional equivalent of a direct discharge, and the remaining factors did not carry any additional weight, so they didn't need to consider those. They only had to look at the first three. And there was either limited or no evidence presented concerning those factors, so we don't have to look at them. So on appeal, the 10th Circuit focused on the 7 factors listed by the Supreme Court in Maui, and here's what they are again. What's the transit time, the distance traveled, the nature of the material through which the pollutant travels. For example, is it going through a wetland which filters out some pollutants? What is the nature of the material through which the pollutant travels? 4, the extent to which the pollutant is diluted or chemically changed as it travels. 5, what amount of pollutant reaches the navigable water compared to how much left the point source. 6, the manner by or area in which the pollutant enters the navigable waters. And 7, the degree to which a pollutant maintains its specified identity at the very end, at the Pacific Ocean or at the river, wherever the water of the United States is. So all those factors had to be examined. And the 10th Circuit said the district court made a legal error in only looking at the first 3 factors. They have to look at all 7 of them. And what the district court should have done is said, you didn't give us enough evidence on the remaining factors. I am going to send you back to examine this and provide the court with more evidence regarding the remaining 4 factors so they could complete their analysis. And once again, the district court, the 10th Circuit reversed the lower court's opinion, remanded it for it to address the deficient Maui analysis. And we'll monitor and see what happens with this case. And as I'll discuss momentarily in the chronological order that we're in here, or the page sequencing, the EPA in November of last year, they actually published in the Federal Register notice of draft guidance concerning the EPA's preferred applicability of the Maui case. I'll talk about that in a minute. All right, the next item here, we're almost through water quality, is item number 3 at page 24, and that's Los Angeles Waterkeeper versus State Water Resources Control Board. And here, this case involves four publicly owned treatment works collectively, they discharge hundreds of millions of gallons into the Los Angeles River, treated wastewater daily into the Los Angeles River and the Pacific Ocean. a Clean Water Act lawsuit brought by a citizen enforcement group, and they claim that, and the lawsuit was brought as the publicly owned treatment works were seeking renewal of their current wastewater discharge permits. So all 4 of the treatment works had discharge permits, but the lawsuit was filed, and the environmental advocacy group, the Los Angeles Waterkeeper, submitted comments suggesting that the publicly owned treatment works, they could recycle and reuse treated wastewater instead of dumping it, and the regional board should conduct a waste and unreasonable use analysis prior to approving the permit renewals in light of the plaintiffs' their suggestions. This was before they filed the lawsuit. They made the suggestion, and the Los Angeles Regional Water Quality Control Board said that's not our job. We only look at water quality. We don't look at reasonable use, and that's not something that we don't have the authority to look at that. So no, thank you. We're not going to pursue that. The plaintiff then, before they filed the lawsuit, went to the State Water Board and said, we'd like you to review the Regional Water Quality Control Board's decision to issue those permits because they didn't conduct a waste and unreasonable use analysis prior to approving the permit renewals in light of the plaintiffs, in light of their suggestions. And the State Water Board declined to do that as well. So then they sued both the State Water Board and the Regional Board, alleging that the California Constitution and the Water Code impose a non-discretionary affirmative duty on the regional and state boards to determine whether water uses are reasonable and beneficial. And this is pretty interesting. So for every entity that would require a permit from either the regional board or the State Water Board before they discharge, they would have to conduct an analysis to determine whether or not there's waste or unreasonable use and whether or not that water could be used for something more purposeful. Plaintiffs also contended that another section of the Water Code imposed a non-discretionary duty on the State Water Board to prevent the waste, unreasonable use, and unreasonable method of use of water. And the LA Waterkeeper further alleged that the regional board issued the permits without conducting a CEQA analysis and providing the appropriate CEQA findings. And the trial court ruled as follows. First, the State Water Board does have a duty under the state constitution, Article 10, Section 2, to evaluate whether the publicly owned treatment works, whether the amount of wastewater being discharged was reasonable before issuing a permit. They said that the Water Board did have that obligation under the state constitution. But they also said the regional board is not legally obligated to assess the reasonability of a discharge because its authority is limited to water quality. And then third, CEQA review was not triggered by the issuance of the permits because wastewater permits are exempt from CEQA under Water Code Section 13389. And the appellate court responded as follows. First, it reversed the trial court's ruling on the State Water Board's power, holding that while the State Water Board does possess a duty to evaluate unreasonable use in general, they also have very broad discretion in deciding how to allocate their limited resources. And the Constitution, the language in Article 10, Section 2, is not a mandatory charge that the State Water Board investigate every potential allegation of unreasonable use of water in the state. And that's the appellate court said. Additionally, the court said the Water Code section cited, they do not constitute an explicit delegation to the State Water Board of responsibility to conduct a mandatory reasonable use analysis as part of their wastewater discharge permitting process. The appellate court affirmed the trial court's determination regarding the Regional Water Quality Control Board that they are charged with authority over water quality, not over water usage. They also affirmed the trial court holding that Public Resources Code requirement for CEQA under 21,000 at SEC is exempted by Water Code Section 13389. And the California Supreme Court denied review. And the takeaway here is it shed lights on how California courts understand the roles, the different roles of the State Water Board and the Regional Water Quality Board boards, all 9 of them, all 9 of the regions, regarding their statutory and constitutional duties with regard to water usage versus water quality. And so maybe this will emerge in the future in another lawsuit, but for now, the petitioners, their attempt to require that has been limited as a result of this case. All right, and then I think we're almost at the end. It's page 27. As I mentioned a few moments ago, item number 7, the EPA issued draft guidance for application of the County of Maui Hawaii Wildlife Fund. It's simply proposed, and we will continue to monitor this proposed. Let's see, what did I have to say else about this? Yeah, the court, I talked about the case already in the County of Maui, the 7 factors, and the draft guidance is only draft, and we will just continue to monitor that and keep you posted. There's some bullet points on it, but I don't think we need to spend any more time on it, but we'll continue to monitor where they're going with regard to that guidance. And then the next item, or the last item on water quality, is at page 29, and this is just a quick note on the State Water Board adoption of changes to the construction general permit in the event that you or clients of yours are involved in any construction activity. There were changes that were adopted in 2022. They actually went into effect this year. This regulates the release of sediment and other potential pollutants associated with construction activities to protect waterways from construction sites. And some of the changes from the 2009 general construction permit include TMDL, total maximum load requirements that were not there previously, and the implementation of those requirements on specific constituents, construction dewatering and discharge requirements, and revised storm-related monitoring requirements. Those were some of the key changes. As I said, they were adopted in 2022. They became effective in 2023. And they, of course, will increase costs and burdens associated with compliance. And so this concludes the key updates on water supply and water quality. And with that, Glenn's going to discuss the section on waters of the United States and waters of the state, also summarized as wetlands. He will commence at page 36 of the outline with item number 1.
Yeah, that's the Sackett versus EPA case. We've had that for the last few years. It's gone back and forth in the federal courts. Well, now the Supreme Court has finally ruled. As you know, the Clean Water Act is the principal federal law that regulates pollution in water in the United States. The primary basis for federal regulation of wetlands derives from Section 404 of that act. Section 404 requires that entities obtain a permit from the Army Corps of Engineers before depositing dredged or fill materials into navigable waters. And the Act only defines that term as waters of the United States, including territorial seas. However, waters of the United States, or WOTUS, as the environmental practitioners like to call it, is not defined in the Act. And over the decades, as you're probably well aware, courts and federal agencies have struggled mightily over the meaning of those words and how to implement them. And there's been much debate, therefore, over the federal government's geographical scope of authority over waters and wetlands. Well, in 2006, if you recall, Justice Scalia of the United States Supreme Court wrote a 4-justice plurality opinion in Rapanos versus the United States. And that plurality opinion held that the waters of the United States are only those that are relatively permanent, standing, or continuously flowing bodies of water forming geographic features that are described in ordinary parlance as streams, oceans, rivers, and lakes, and not occasional, intermittent, or ephemeral flows. Now, as for wetlands, the plurality in Rapanos found a mere hydrological connection was not sufficient to fall under the Clean Water Act authority, and wetlands must have a continuous surface connection to a water in the United States that makes it difficult to determine whether the water ends, where the wetland begins. Now, alternatively, as you recall in Rapanos, Justice Kennedy gave a different test in a concurring opinion that he wrote, and that was that wetlands that are not adjacent to traditionally navigable waterways must have a significant nexus with one. And after that Rapanos case, most federal agencies, of course, asserting their authority as broadly as possible, and many courts adopted that Kennedy significant nexus test that gives more authority to the government. That's so yesterday. After last year's Sackett case, that all changed. The majority in Sackett went through a long analysis of the history of all of these things and rejected Justice Kennedy's significant nexus test. He adopted the plurality, the majority adopted, a clear majority adopted the plurality opinion of Justice Scalia. So the court conclusively decided finally that jurisdiction under the Clean Water Act for adjacent wetlands exists where the wetlands are indistinguishable from streams, oceans, rivers, and lakes. In other words, the wetlands must have a continuous surface connection with those bodies of water. Now, the EPA, however, jumped in. This is item 2 on page 38. In January of last year, before the Sackett opinion came down, the EPA and the Army Corps of Engineers had published a final rule revising the definition of WOTUS. And of course, they were adopting the broadest possible authority that they could have. But then after Sackett happened, those agencies had to go back to the drawing board. And on September 8th of last year, the agencies published their revised final rule. The new rule went into effect the day it was published. The agencies did not invite any public comment, citing the good cause exception to the notice and comment rulemaking in the Administrative Procedures Act. Now, among other things, I'll just highlight just a few here. The new rule makes a few of the changes. First, of course, there's no longer the significant nexus test that's available following Sackett. Secondly, the term adjacent is more narrowly defined. It is now, adjacent means having a continuous surface connection. Third, the new rule eliminates the other waters category that the government had expanded its authority into, and it requires that streams and wetlands be located in the rule's definitive categories in order to be found jurisdictional. Something else here is that the revised rule requires that tributaries be relatively permanent, standing, or continuously flowing bodies of water in order to have jurisdiction over them. And there's other changes in the final rule. They're in your materials on pages 38 through 40. Now, as expected, like every single change we've seen when the EPA and the Army Corps got involved in these definitions, it has been sued. Again, the state of Texas and Idaho, that's actually where the Sackett case opinion arose, and more than a dozen industry groups have challenged the new rule on the grounds that the rule fails to conform with Sackett. It's still too broad, in their opinion, and also that the agencies violated the APA by refusing to accept a public notice and comment during the revised rulemaking process. So, even though we now have more clarity on the definition of WOTUS, as to federal implementation through federal regulations, that's still uncertain. So, of course, the lawyers are still employed. Let's move to air quality if we could. And I'm sorry, my clicker here isn't working. It's intermittent here. Let's go to the first case, item number 1 on page 44.
And I think I'll be handling that, Glenn?
Let's see. Yeah, why don't you go ahead and take that?
Perfect. All right. Thank you, Glenn. Appreciate the update on Sackett again, on the saga of Sackett. So we're at item number 1 at page 44, as Glenn stated, and this case is all about the aircraft rule, and it centers on aircraft emission standards and the EPA's decision to adopt internationally recognized adopted standards in lieu of setting technology forcing standards, as California is commonly known to do. This is not well, it is a California case, but this case has obviously significance beyond California. But there's a few central facts regarding aircraft carbon emissions I want to talk about here. So one of the facts is it's estimated that air travel accounts for about 4% of human-induced global warming and airplane emissions may triple by 2050. So right now, we're at 4%. It's anticipated maybe by 2050, it could be 12% of human-induced global warming caused by air travel. The good news, however, is that jets are becoming much more efficient, and they are working on technology to improve that. The concern, however, is that the traveler's appetite for travel we don't want it to outpace the industry's environmental gains. So the industry is aware of the issue, but right now it appears as travel may be outpacing it, so they don't want that to happen. Next, as to short-haul flights, it's kind of like the same when you're in a car. Short-haul flights appear to generate the most carbon emission, and a short-haul flight is deemed to be under 3 hours, 30 minutes to 3 hours, whereas medium haul is 3 to 6 hours, and long haul is more than 6 hours. So if you want to not have as many carbon emissions be contributing to that, go to Europe, don't fly to Chicago. So that's the but those are just some interesting statistics I thought you might want to know. The framework, though, for this litigation began in 2016 when the US EPA issued their endangerment findings about air travel. And it said that greenhouse gas emissions from certain classes of engines used in aircraft, they contribute to air pollution and they cause climate change, endangering the public health and welfare. And as a result of these endangerment findings, the EPA was obligated to adopt standards to remediate that impact. And that's exactly what they did. But in the following year, in 2017, an entity called the ICAO, which is the International Civil Aviation Organization, they adopted a set of standards to address the aircraft emissions concern. They approached the issue from a technology following, not technology forcing angle. And it was designed to align with performance and technology currently available in existing airplanes instead of the technology forcing approach, which required the aviation industry to develop new technologies to comply with the standard because it felt they were already doing that anyway. So the ICAO adopted this set of standards. So in January, so that's 2017, so in January 21, the EPA ultimately adopted the ICAO's technology following rule to satisfy the obligation to reduce greenhouse gas emissions. There is also a convention to which the EPA is a party, and under that convention's conditions, the ICAO standards are the floor, not the ceiling of what the EPA could impose. So if the EPA chose to promulgate more intensive standards and more stringent standards, they would have to notify the ICAO immediately, but they could do that if they chose to do it. But the EPA did not choose to do that. They instead decided to remain consistent with the ICAO standards. California and 11 other states, as well as the District of Columbia, filed a petition for review on January 15th of 2021 because of the EPA's decision to adhere to those ICAO standards. And very quickly after they had adopted their emission standard, the ICAO's emission standards. And the petitioners argued that the EPA had failed to consider factors required under the Clean Air Act for establishing regulations related to the reduction of emissions. The court rejected the argument, explaining that the Clean Air Act does not require EPA to consider specific factors. Instead, it grants the discretion to the EPA to determine and apply whatever factors they think they need to apply. Next, petitioners argued that the Clean Air Act requires the EPA to consider emission reductions that are feasible, more of the technology forcing approach. Once again, the court clarified that in the absence of plain language in the Clean Air Act, the EPA had the broad discretion to determine and adopt the ICAO standards, those minimum standards, which is what they chose to do. And finally, they argued that the EPA acted arbitrarily and capriciously by neglecting to consider the harms of climate change in its own regulations. The court rejected this argument by explaining that the EPA's alignment with the international ICAO standards was the most reasonable way to reduce greenhouse emissions globally. It's because of the international nature of air travel and the necessary cooperation between countries, and the treaties, such as the other treaty that I mentioned, to work toward mutual environmental standards. So there was every reason for the EPA to adopt the ICAO standards. And it actually aligns with what the EPA had previously done in adopting ICAO standards in prior circumstances decades earlier. So the EPA was not doing anything unusual by adhering to the ICAO standards. And we will see if that case, that is appealed, but for the moment, there has been no appeal filed. We'll continue to monitor that. The one other air quality case I'm going to talk about, Glenn, I'm jumping to page 50, item 8. I'm passing on Navarro because we don't have that much time. And I'm going to talk about Ohio, very quickly, Ohio versus EPA. There are several Ohio versus EPA cases out there right now. This one has to do with the California waiver. And very quickly, in Ohio versus EPA, it's now pending before the DC Circuit. Various industry and state petitioners, 16 states, including not California, 16 states, including Ohio, challenged the EPA's reinstatement of California's waiver, allowing California to set its own stringent emissions standards, greenhouse gas emission standards. So they're protesting that. They argue that their actions reinstating the waiver are preempted by the Clean Water Act, and Congress has not implicitly authorized it. They also argue that the federal government is showing favoritism to California in contravention to the Constitutional's equal sovereignty principle, which the Supreme Court has long recognized in a long line of cases. So we will continue to monitor that. We think this will end up in the United States Supreme Court, and there are quite a few states that don't think we should be able to have our waiver and accept and set our own standards. But for now, California is enjoying the waiver and is creating its own emission standards and complying with its own emission standards.
Yeah, every administration
And then
change,
Glenn,
we get more
you'll take
litigation on that one.
us to page 51 of the outline at item number 9, according to my notes.
Okay, here. Why don't we do that? The new emission rule for heavy-duty vehicles. You know, in March of last year, the Environmental Protection Agency adopted a rule that targets the ground level ozone and particulate matter pollution from heavy-duty vehicles. That final rule goes into effect for model year 2027. They're much more stringent than before. They cover a wider range of operating conditions for heavy engines, and standards must be met for a longer period of time when those engines are operating. Also, the final rule will amend air pollution emission standards for light-duty vehicles, marine diesel engines, locomotives, and certain non-road vehicles and equipment. Going through a number of these different air quality things, why don't we also look at item number 10 on page 51. The EPA finalizes the rule to strengthen the primary NAAQS threshold for particulate matter. That is for soot, and that happened last month. From 12 micrograms per cubic meter to 9. Of course, no one is happy. The environmental and public health advocates wanted it lower. The U.S. Chamber of Commerce wanted it left alone. The EPA, however, did not alter the existing secondary NAAQS for particulate matter. Then let's also look at item 11 on page 52. The GHG emission standards for cars and trucks. This is May of last year. The EPA published a proposed rule that would make higher emission standards for greenhouse gases, criteria pollutants for new passenger cars and light-duty trucks for models year 2027 through 2032. Some have suggested that only Tesla can actually satisfy those requirements as the technology now exists, and public comments on the proposed rule closed last year. However, the final rule, we found out last month, may not end up quite as aggressive as the proposed rule because due to political considerations in the election, the Biden administration made an inside deal, which we don't quite know quite yet, according to the New York Times, with both auto manufacturers and the unions, because they want to slow down the development of the EVs, because not only the lack of charging stations, but also because they believe that it's going to throw people out of work, and the whole auto economy would move to those states in the South that do not have a whole lot of unionization, and so that's been slowed down. We'll see what happens on that one. Item number 13, page 54, the methane rules for the oil and gas industry last December. They were intended to reduce methane and volatile organic compounds from new facilities and methane from existing facilities. Basically, the flaring of natural gas from the new wells will be phased out. So why don't we move to climate change itself and renewable energy. And item number 1 on page 74, we have the BLM proposes new rule to bolster solar and wind development on public lands, which, as you know, the BLM manages about 10% of the country's entire land mass. And to build an energy project on public lands, the BLM charges developers rental fees on the land, additional fees based on the energy produced. June of last year, the BLM published a proposed rule that's designed to increase the solar and wind projects on public lands. Public comment already closed last August. It's under the Renewable Energy Rule that actually implements the Energy Act of 2020, reducing these acreage rents and capacity fees by up to 80%, basically trying to compete with the oil and gas projects. Then item number 4 on page 76, last October, the Governor Newsom signed Senate Bill 253, the Climate Corporate Data Accountability Act. And it requires, this is a big deal, because the companies conducting business in California, but organized in the United States, that have a total annual revenue in excess of $1 billion, must report their greenhouse gas emissions annually. And that act also requires that companies begin submitting their reports of GHG emissions beginning in 2026. He also signed Senate Bill 261, the Climate-Related Financial Risk Act. Companies that are, again, conducting businesses in California, organized in the U.S., annual revenue of $500 million, need to report their climate-related financial risks. Under that act, not only they need to report their climate-related financial risks, but also the measures that the entity has adopted to reduce and adapt to climate-related financial risks. That reporting begins in 2026. However, in January of this year, the United States Chamber of Commerce, the American Farm Bureau, a bunch of other business organizations filed a lawsuit in federal court in Southern California. They're alleging that not only are these reporting requirements preempted by the Federal Clean Air Act, but also that they violate the First Amendment to the extent that they require or compel unconstitutionally, they compel speech. Now, so we'll see what happens to that litigation as to the California rule. However, the Biden administration is pursuing a similar approach at the federal level. And last week, the Securities and Exchange Commission approved a final climate change disclosure rule. It goes into effect 60 days after publication of the Federal Register, which hasn't occurred yet. And looking at the experience under the California rule, I can only imagine we'll be here next year with a new federal lawsuit to talk to you about. Endangered species. Do you want to mention anything in that category?
I do.
Okay.
Thank you, Glenn. So everyone, we're going to go. We have time, a little bit of time. We're doing all right on our time. So at page, let's see. Oh my gosh, what page is it?
I think you're at 82 on item 3.
I think we're at 82. I'm going to item 2, and I'm sorry I didn't write my page number here in my notes. It's the Center for Biological Diversity versus U.S. Fish and Wildlife Service out of the Ninth Circuit. I want to talk about this case a minute because it's emblematic of a unique issue that happens when the U.S. Fish and Wildlife Service lists a species and they don't identify critical habitat. And it's very common. They usually don't identify critical habitat until they get sued because they just don't have the staff to get it done. But a unique issue arose here because of the late finally identifying what the critical habitat would be, and I'll talk about that here. So in 1997, the United States Fish and Wildlife Service listed the jaguar as endangered domestically, but they didn't designate the critical habitat at that time. And in 2009, after following litigation, they took steps to designate the habitat. And in 2014, a final rule was promulgated that designated about almost 800,000 acres in Arizona and New Mexico as critical habitat. All right, so that's back. So now fast forward, we have a mining project. And this case occurred within the context of that project that was approved on land designated as critical habitat for the jaguar in Arizona. And after the United States Fish and Wildlife Service published a biological opinion concluding that the mining activities were not likely to destroy or adversely modify the jaguar's habitat, critical habitat, an environmental group filed a lawsuit. And they challenged the approval. The mining operator intervened and cross-claimed against the United States Fish and Wildlife Service, alleging that it violated the Endangered Species Act and the Administrative Procedures Act in designating the land that included their project area as critical habitat. So here they are years later coming in for a critical habitat designated in 2014. Fast forward, and they are filing a lawsuit under the APA saying they never should have designated this land in the first place. And here's why. Ultimately, I will say the district court, the lower court, ruled in favor of the mining operator concerning the occupied critical habitat designation and in favor of the U.S. Fish and Wildlife Service as to the unoccupied critical habitat designation. And generally, the ESA divides critical habitat designations into both those categories, occupied and unoccupied. And for both determinations, they have to be able, the listing must be, quote, essential to the, quote, conservation of the species. The ESA does not define essential, but in this case, the court applied the ordinary meaning of the term essential and determined that the ESA demands that the listed area be indispensable or necessary to conservation, not merely beneficial. So beneficial is not enough, it has to be essential, indispensable, or necessary to be essential. So the Ninth Circuit on appeal held that United States Fish and Wildlife Service actually acted in a manner that was arbitrary and capricious. Now this is unusual. The Ninth Circuit really is the circuit, the appellate circuit in the United States that has the most environmental cases for myriad reasons, but they are at the center of a lot of environmental controversies. And here they held that U.S. Fish and Wildlife Service was acting arbitrarily and capriciously when it determined that land was occupied by the jaguar. And that is because that the ESA requires Fish and Wildlife Service to determine occupancy based on the time of the listing, which in this case was in 1972, not in 2014. The U.S. Fish and Wildlife Service relied on photographs from 2012 and 2013, some several decades after the listing. That listing was overturned as a result of that. Second, they reversed the district court's decision concerning the unoccupied critical habitat, saying that Fish and Wildlife Service had failed to prove the area listed as unoccupied habitat was essential to the conservation of the jaguar, after finding that there was absolutely no evidence in the record that the jaguar had ever frequented the areas at issue or ever would. Rather, the U.S. Fish and Wildlife Service acted in a manner that was arbitrary and capricious in speculating that the jaguar had utilized the area. So maybe the jaguar had been there, but the U.S. Fish and Wildlife Service did not present enough evidence in the record to justify that. So this is yet another issue that comes up in terms of what's in your record and evidence with a habitat listing so many years after the original listing of the species. Okay, and then I'm going to talk about item number 3. Don't have the page number, but it's right after item number 2. And this has to do with the adoption of a recovery plan for the grizzly bear. And it had been listed as a threatened species since 1975. And in this case, the Court of Appeal held that the adoption of a recovery plan under the ESA is not a final agency action and is not reviewable under the APA. And in 2014, let's see, the grizzly bear was listed. All right, so in 2014, an environmental group sued U.S. Fish and Wildlife Service asking them to revise their 1993 recovery plan. So the species was adopted in 75. Recovery plans were created. The latest one was from 1993. And they wanted the plan to identify additional geographic areas where recovery strategies could occur for the grizzly bear, and they wanted it across their entire native range. The petition contended that the service had failed to develop adequate recovery strategies for ecosystems that still contain suitable habitat for the grizzly bear. And it proposed some additional recovery zones in 4 states, but the Fish and Wildlife Service denied the petition, contending that neither the ESA nor the APA authorizes petitions to create or revise recovery plans. And then, the lawsuit ensued, and district court gave United States Fish and Wildlife Service dismissed the case on the service's motion for summary judgment and agreed with the service that a recovery plan was not a rule under the APA. Plaintiff could not file a petition seeking to amend the plan. Plaintiff then appealed it, and the Ninth Circuit agreed. And their reasoning was, first, the appellate court conceded the term rule applies to a broad class of agency action, and a recovery plan is a rule. However, the court reasoned the APA only grants federal courts jurisdiction to review agency action made reviewable by statute and final agency action. Since plaintiff did not contend the plan was reviewable by statute, the issue becomes whether the recovery plan is final agency action. And the Supreme Court has a 2-factor test, whether the agency action is final. It has to, 1, mark the consummation of their decision-making process. It can't be tentative or interlocutory in nature. And 2, it is one by which rights or obligations have been determined or from which legal consequences must flow. The court held that while recovery plans may satisfy the first factor, they do not satisfy the second factor. Thus, it follows that a decision to not grant a petition under the APA to modify a recovery plan is not a final agency action reviewable in federal court under the APA's judicial review provisions. Okay, and so I'm just going to talk for a few minutes. I created a chart to make this easy. I had Tiara create charts in our PowerPoint of a whole lot of listings that happened this year. U.S. Fish and Wildlife Service was very busy. So I'm looking at pages 86, and this goes through 92 for items 7 through 18. So the first chart, you see hopefully this is helpful. So the first one is the listing of the western spadefoot toad, which apparently doesn't look like a toad at all. I should have put a picture up here. It does look like one, but in reality, it is not a toad. And what they have published is a proposed rule to list 2 population segments, okay, as threatened. So we've got proposed rule, 2 segments threatened. All right, the next species, number 8, is the wolverine. And in November, a final rule was published by Fish and Wildlife Service, officially listing 1 distinct population segment of the North American wolverine as threatened under the ESA. They look like small bears, if you have never seen a wolverine. All right, the next one, item number 9, is United States Fish and Wildlife Service again considers ESA protections for salamander species found in multiple California counties. And so they formally reopened public comment concerning a proposed rule to list 2 species of salamanders found in Kern, Inyo, and Tulare counties for protections under the ESA. The next item, the U.S. Fish and Wildlife Service, item number 10, proposed protections it's a proposed rule to list as threatened 2 species of turtles. One was the northwestern pond turtle, found locally in northern and central California, and the southwestern pond turtle found in central and southern California. And with a proposed listing of these species, they're also proposing a special 4D rule that thank you, Janine, that exempts activities related to fuels management to reduce the risk of wildfires. So from the ESA take prohibitions, so you can still take the species if you're conducting fuel management to protect from wildfire. And that's interesting that they've listed this, and we may see more of this with the wildfire issues when there's a proposed rule for listing. And the next one is number 11, and that's the United States Fish and Wildlife Service actually lists the Lasix lupin as an endangered species. That happened in October, and it's only found in Northern California, and so it's now protected as endangered. The next one, item number 12, 4 population segments of foothill yellow-legged frog received protection. Published a final rule listing 2 population segments of the foothill yellow frog as endangered and another 2 as threatened under the ESA. I'm not sure if they're listed under both columns, but 2 segments are endangered, 2 are threatened, and the rule is final. It's not just proposed. 2 more, again, under the federal ESA, a final rule listing a pine as threatened went into effect in January of last year. And then under one more, item number 15, listing of the California spotted owl, 2 distinct segments, and it's a proposed rule on the owl. And item number 16, another federal listing, northern long-eared bat. It was reclassified as endangered. It was originally threatened, and now it's deemed endangered. 2 more items. These are under the California ESA 2 listings. Item 17, the San Bernardino kangaroo rat is listed as endangered. That is a final rule. And then 18, the greater sage grouse is closer to receiving protections, and to list them either as threatened or endangered, it's just proposed. Okay, and so we only have a few minutes left. I think, Glenn, you were going to cover one item in hazardous materials. Do you want to try that, and then we'll wrap it up?
Real quick here.
Thank you.
We have PFAs. Those are the per and polyfluoroalkyl substances, or PFAs. They're basically known as forever chemicals because of their intrinsic structural strength prevents them from breaking down naturally in the environment or biotic systems. What happened is last month, the EPA, and this is item number 3 on page 100, it published 2 proposed rules that would amend the RCRA, or the Resource Conservation and Recovery Act. One would add 9 specific PFAs to the list of hazardous constituents under RCRA. And then also the EPA's second proposed rule modifies the definition of hazardous waste under RCRA as it applies to cleanups at permitted hazardous waste facilities. That rule is intended to ensure that EPA's regulations reflect the authority to require cleanup of the full range of substances that RCRA intended, including PFAs. Then item number 4 on page 100, all right, there we go. Governor Newsom actually vetoes 2 bills. Now, in 2022, there were 2 laws dealing with PFAs in the manufacture, distribution, and sale of clothing and in cosmetics, and that was prohibited to go into effect in 2025. So the legislature got involved last year, proposed Assembly Bill 727 and passed it to prohibit the manufacture, distribution, and sale of cleaning products and also floor sealer and floor finishes that intentionally added PFAs. The governor last October vetoed that bill and basically said that there was lack of regulatory oversight in the implementation of that new law. He was concerned about inconsistent interpretations and confusion among manufacturers as to how to comply. And also, he has been swayed in the past by the fact that the implementation costs would be very prohibitive to industry. We'll see what happens this next year to see if maybe they have an even more robust bill that is passed. Want to go NEPA or?
I think it's time to conclude.
Right,
Janine's
okay.
given us that. So
Very good.
what I'm going to recommend, when you have time, feel free to look at the remaining sections from NEPA, wildfire management, forest resources, any of the mining, oil and gas, any of the other items, environmental enforcement. If you have any questions, feel free to call us. We're happy to chat with you anytime. And we truly appreciate, once again, your attendance in person. It's kind of nice to be together in person. And we appreciate you listening, and we're here if you have any questions now or in the future. Thank you so much. We're going to take a 15-minute break, and then we'll come back with Glenn doing real estate and the takings items and his Supreme Court case to the extent what he can discuss on it at this moment. And then Bill and Gage will follow up with the CEQA planning and zoning laws. Thank you so much.